So again, it's clients love fierce counsel, courts feel differently, which is confidentiality, loyalty, financial responsibility, competence, candor, fairness, and decorum. So those are all of your major PR issues. Okay, so let's go through this fact pattern a little bit. So it's Alice's and Bob's law firm, AB Law, is a limited liability partnership. So there, obviously, we see it's an LLP, so I know I have a partnership, and it's between the two of them and then their law firm. The firm represents SID, a computer manufacturer. SID sued Renco, his chip supplier, for illegal price fixing. So then you have a representation, so you have an attorney-client relationship. I always like to start out defining that at the beginning. So I like to start just set that out, and then you have what they've represented them for. Next paragraph. Renco's lawyer asked Alice for a brief extension of time to respond to Sid's interrogatories because he was going on a long-planned vacation. Sid told Alice not to grant the extension because Renco had gouged him on chip prices. So there you have, obviously, the first issue here. So there you have that first issue, and it's with the client. It's with the client trying to tell the attorney what to do, which is something on a matter that is within the attorney's control. And you have to remember, a lot of people don't like that, but it's okay to deny a discovery extension. There's no duty to grant it. So that gets to our first call. She denied the request for an extension. Sid also told Alice that he'd had enough of Renco setting the case's pace, so he wasn't going to appear at his deposition scheduled by Renco for the next week. And that he'd pay his physician to write a note excusing him from appearing. Alice did nothing in response. So there you have a communication between an attorney and a client, which triggers a duty of confidentiality. So there's that. But there are the exceptions if it's going to be the exceptions for crime, fraud, and serious financial injury. So you'd want to talk about that. So you'd want to talk about all of that. Then you also have him talking about the pace. You have the client basically saying that he's going to lie and not show up at his deposition, which can obviously be problematic. You have the duty of fairness to opposing counsel. So that comes in there. So Alice did nothing in response. So in the course of representing Sid, Alice learned that Sid planned a tender offer for the publicly traded shares of chip maker Chipco. So with that, then you have Alice learning something. When Alice learns that, then she has to keep it confidential. And keeping it confidentiality, or the duty of confidentiality, doesn't discuss just keeping information confidential. It also is that the attorney cannot use that information either. So it's keep confidential and do not use. Alice then bought 10,000 Chipco shares. By buying the 10,000 Chipco shares, she drove up the price that Sid had to pay by $1 million. So now Alice does that, and it costs her client $1 million. When Alice sold the 10,000 Chipco shares, she realized a $200,000 profit. So then that also triggers some problems that Alice did. That she's profiting off of it, and then there is a potential claim that Sid would have against both Alice and, well, really against Alice, AB Law, and then Bob. So it's a limited, but it's an LLP. So we're going to talk about that a little bit. All right, so let's go in. So I listed out my issues. These are all the issues that I saw. So first, I'm going to start with Alice's ethical violations. So I always establish there's an attorney-client relationship. So I'm going to do that first. So S hired AB Law for price fixing suit. So, and the reason I do this is I just like to establish this relationship and all the duties are owed. So it's just a little thing. You don't have to do it, especially if there's a whole lot of issues, but I also like to do it because then it gets me thinking about, what is owed. And sometimes it's helpful to do this too when there are multiple attorneys. So when there are multiple attorneys. So there have been essays where they have, two clients against each other, and each side's attorney is doing something. So that's why I like to set it out, who's representing who. It kind of just helps me get it straight in my head. All right, so then with respect to the discovery extension. So here we talk about allocation of attorney-client authority. Let's fix that. So allocation of authority. So attorney controls the client controls the ends, the attorney controls the means. So it's with So first I'm gonna put the facts in. So here it's just a brief extension of time. It's just a brief extension of time, which I think is probably reasonable. And it's for a long planned vacation. So those are a couple of facts with respect to the vacation that make it, seem like, that maybe Alice should grant it, but there is no duty. So no duty to grant extensions. It's just a brief extension of time, but it doesn't violate anything. So no duty to grant an exception, even though it's for a brief extension of time and it's for a long planned vacation. They still don't have to do it. Further, I would mention that it's often is good for an attorney to do what their client wants, as long as it's within the scope of what they're allowed to do. What client wants. So that's often allowed, and I think this is okay. A lot of people argue on this one, and I think you can make the argument, but a lot of people like to talk about the duty of fairness to opposing counsel, but you're not doing anything unfair by denying it. So I think that it's okay, but you can raise that, and I would dismiss it. I think that this is an issue that really there's no ethical violation being committed. Okay, so that's really it. So I think so I'll put my conclusion. No ethical violation. So that first issue is pretty easy. All right, the physician's note. This one is a little bit more complicated, and you can tell that it's complicated doing it. So you could talk about the duty of fairness in here. So hold on, let's pull. So with this one, the duty of so she can do it if she chooses. So here, though, you could use the facts again. We want to make sure that we're using all the facts. So you could also use the fact that they're doing this because Renko had gouged S on chip prices. So you're kind of doing it just to get back for something else, but it's still okay. So I just have all of these in there that there's no duty to grant it, and even though it's brief for a long planned vacation, and Renko had allegedly done something bad, it doesn't, and that's the sole reason for doing it, it's okay. All right, so there's no ethical violation there. Okay, so the physician's notes. So duty of confidentiality. So A has to keep communications confidential. So Sid told Alice he'd had enough of Renko setting the pace, so he wasn't going to appear at his deposition scheduled by Renko. So duty of confidentiality. So Alice did nothing. So here, Alice did not tell Renko. That the reason for it. The reason for canceling was false. So she does have to keep that confidential. So there is that issue, is the confidentiality, and you do have the crime, fraud, and the financial harm exception. So a lot of people talk about that here. So what do you guys think? So crime, fraud, financial injury. Did you guys see that? There was always a lot of debate on this, so that's why I'm curious. That's why I'm asking. Okay. Yeah, so did you think that there was a violation, though? Or do you think that you could use that to breach the duty? So I'll start putting in the facts here. So Sid said he wasn't going to appear at his deposition, going to pay physician to write a note excusing him from appearing, which is false. Yeah, okay, good. Yeah. So you could say there would be a fraud to lie to the other party or intend to deceive, all of that. I think that it kind of goes beyond I think it kind of goes beyond to say that it's a fraud. Um I think that's for a little bit of a stretch, but I think that you could talk about it. I think that you can bring it up, but I totally think you can go either way on this. People definitely do go both ways on this. Um, so could amount to fraud um, because intent to deceive and get back at um, or will not get back, intent to deceive and solely to bar R from setting the pace. So you have that. It's also, there's some potential financial harm um, because depositions are expensive and waste of time for attorneys, parties to appear. So there's all of that, but ultimately I don't think that this is going to be a fraud. I don't think there's enough. There is some intent to deceive, but I don't think that the court's going to amount to that. And the financial injury, I don't think is going to be enough. So, let's do it. Although R will suffer financial injury, not enough to amount to, not enough to meet the burden here. Because I think it has to be a substantial burden, a substantial financial harm. Likely not fraud because it's just not, because I don't think it's serious enough. Yeah. Okay. So so there isn't a breach of the duty of confidentiality. No reveal by A, so no violation. Duty of fairness to opposing counsel. So per the duty of fairness, okay. Yeah, and the reason, so the fraud is it goes along the same line. So it's not certain to result in substantial injury to the financial interests. Okay. So, and then duty of fairness to opposing counsel. So you have a duty to behave honestly in all dealings. So so you have a duty to behave honestly. So here, I think is, okay. So here, I think getting, allowing a client to not show up at a deposition, and getting a falsified note, is inherently dishonest, and would violate confidence, would violate public confidence in the bar. And so I think that there is a duty of fairness violation here. But it's tough because Alice could probably counsel her client, say not to do that. Counsel the client to say, just to reschedule it, and let her client know. I mean, the client, Sid here is really, he has a court order. I mean, that's what it is when you get a subpoenaed for a deposition. It's a court order. So by violating that, you are violating the court. So I definitely think that there is a duty of fairness violation here, by allowing this to occur. Because she could probably, change the result without revealing confidentiality by properly counseling her client, or potentially even withdrawing because your client's making it somewhat difficult. So I think that there are things that you can do here. All right, and then also the duty to expedite. So that which a lot of people forget. Under the ABA, an attorney has an affirmative duty to expedite a case. So, and then under the California rules, an attorney may not delay or harass, may not delay just to harass an adversary or for his or her own personal gain. You could also talk about this with respect to the discovery extension, but I don't think that it would fly because it's kind of the opposite. So it's the opposite because you're forcing someone to do something sooner. So that's why I didn't talk about it. A lot of people bring it up when I mention it here. They mention it for the discovery extension, but it doesn't apply there. So, and it doesn't apply because not granting an extension means the case is going to go faster. So duty to expedite here, that means, so if S doesn't appear for a deposition, then it will delay case because he has to be deposed. That's a question. Right. So yeah, so Maria, that's a good question. So yeah, you cannot force your client to go. You can't, but you should probably properly counsel your client. Alice didn't tell him not to go, so she can just she could tell them that they might get sanctioned if anybody were to find out. Yeah, and I mean, I think that she could also probably say, look, you can't do something like this. Like, I have ethical duties, and the fact that, I mean, I think the problem here is that she did nothing. So I think that's where the problem is. But yeah, she could definitely tell him that he might get sanctioned. Absolutely. And she cannot tell the opposing side. She cannot tell the opposing side. That's the big thing, because that would probably breach the duty of confidentiality, unless you found that it was, a crime, fraud, or financial harm. But I just don't think that it would amount to that because it's not a substantial enough injury. All right. So because he must be deposed, so duty to expedite. So that's going to cause a delay. So under the ABA, so under ABA, this probably delay for no good reason. And it's not even for not a good reason. It's delay solely to stop Renco from setting pace is not valid. It's an valid basis for a delay. And then in California, this is you're doing this really just to kind of harass the opposing side. So not showing up. Is done solely to stop R from setting the pace. So I think that there's a violation of the duty to expedite here as well. Does that make sense? Anybody have any questions about that or anything else so far? Okay. So okay, makes sense. Okay, good. Thanks, Martha. Oh, ABA in California for which one? For duty to expedite? I'll put it up on the screen. Oops. So duty to expedite here, it's right here at the bottom third, Martha. So under the ABA, an attorney has an affirmative duty to expedite a case. Under the California rules, an attorney may not delay to harass an adversary or for his or her own personal gain or convenience. Okay, cool. And then the duty, so then, and then we got to go on to the CHIPCO tender offer. CHIPCO tender offer. So there is the duty of confidentiality. So that means you cannot use the information. So you cannot use the information here. Alice, learned that S planned a tender offer for CHIPCO in the course in the course of representing Sid and bought 10,000 Chipco shares, which cost Sid $1 million. So she breached her duty of confidentiality there. That's absolutely a violation. Oops. So duty of confidentiality. Okay, so, and they said there's obviously Sid didn't consent because Sid wouldn't consent to, which cost it, Sid wouldn't consent to it. $1 million. Okay, so there's a violation. That's pretty clear cut. Violation. Okay, then also duty to uphold the law. So this is what a lot of people miss. So duty to uphold the law. So a lawyer has to may not commit a criminal act that reflects adversely on the attorney's honesty, trustworthiness, or fitness as a lawyer. So here, under Federal Rule 10b-5, nobody can trade information, trade on based on market information and breach of a duty of trust. So cannot breach of a duty of trust owed to the source. So here, Alice owed Sid a duty of confidentiality as S's attorney, traded based on information that she learned in breach of duty of confidentiality. So the violation of duty to uphold the law. How many of you guys saw that and saw that there was a 10b-5 violation? Oh, good. Yeah, some of you guys saw it. Yeah. Yeah. Yeah, I mean, it's not huge. I wouldn't have like headlined it, but I would have done like duty to uphold the law, and then I definitely would have talked about that. But it's just you want to see that that's why they say in the course of representing Sid, Alice learned that. I think a lot of people miss that issue, but you have to ask, why are they telling you that it's publicly traded shares? They're doing, they're telling you that and that she bought shares and it cost. And there are other ways you can use those facts, but this is when she's doing something that doesn't seem right, you have to ask yourself, is it a criminal act? And if it is, then there's a duty to uphold the law also. So duty of competence, no reasonable attorney. So you have to act, so I would say, and a lot of times you can throw this at a competent attorney with acting with skill, thoroughness, and preparation would not do this. Breached duty of confidentiality and cost her client $1 million to gain a profit. So there's a duty of competence violation there too. All right, and then let's look at Sid v. Alice, A.B. Law, and Bob. So you notice that like most of the facts in here are related to, a lot of it is the PR issues. So that's going to be the bulk of your essay. But here there's also, but they do tell you that it's a limited liability partnership. So then you want to get to that. So when asked what claim, if any, does Sid have against Alice, A.B. Law, and Bob, you can say that there's a contract that's been formed because there's a contract to represent. Contract. Let's see. There's a contract to represent Sid. So, and it's been breached because violated duty of, etc., as established above. So then Alice, A.B. Law, and Bob would be liable. So it's a limited liability partnership. So It is a limited liability partnership. So with that, well, first of all, there's probably an unjust enrichment here. So even if there wasn't a contract, you could say that there is probably an unjust enrichment, and they could get back that you could get the $200,000 back. So even if no contract, recover restitution, which is the 200. So you're going to basically disgorge the profits. But then you talk about that it's a limited liability partnership. So for an LLP, limited liability partners are liable for the obligations of the LLP, but limited partners are not personally liable for LLP. They're not personally liable for LLP obligations, but a limited partner is personally liable for his or her own misconduct. So here you would want to talk about Alice, AB Law, and Bob. So Alice is going to be liable for her own misconduct. And the partnership is also liable for Alice's misconduct. Because she's a partner. And then Bob is not personally liable. So when they list the individuals like that, like, yeah, Bob is liable through AB Law, but that's AB Law's liability. Bob is not personally liable. So when they mention individuals, this is also what triggers a Pearson the corporate veil analysis, just so you know. When it lists individuals and a corporation, and the individuals are members of the entity, then it's asking you, okay, well, can you get to those people individually, and can you also get to the business? So you have to look if you're going to pierce that corporate veil. So that's how you kind of look out for that fact. Does anybody have any questions about that? Or about this essay in general, rather? Okay. All right. So there's kind of there's a lot of different duties in there. This one, I think there's if you when you look at this one, there's not as many issues as we see. Adam, I'm actually not sure what your question is there. This is it. That's all that you would talk about for this essay, if that's what you're asking. It asks what claims. So the claims, if any, just did have, and the claims here is really just a breach of contract action. So yeah, that's why I say breach of contract. You would talk about that, and then if you don't have that, then you could show unjust enrichment because it shows that the firm represents Sid. There's presumably a contract there, and then the reason they're giving you the liability is because they want to know who can be personally liable. So it's asking what claims does Sid have against Alice, AB Law, and Bob. No, you're not going to get into a negligence claim here. Yeah, no, you wouldn't get into a negligence claim here because it's not negligence. But the reason they're saying that have against each of them is because they want to know what claims do they have, and like what is against each of these people or the entity. So, all right, so I'm going to give you guys 30 minutes to do this one then, with Online Ink, which is now up on the screen, and I'll make it full screen so you can see it. All right, so I'll see you back at 7:35. All right, you guys ready? Okay, good. Good, good. So, oh, strange. Okay. Um, so first of all, we're going to start off by reading a call to question. It says, what are Dick's rights and remedies, if any, against Jane, Sam, and or Harry? So it's asking about multiple people, so I don't quite know what subject I'm in. And then the call 2 is what ethical violations, if any, has Harry committed? Discuss, answer according to California and ABA. So when I see that, I know that I'm in PR, and then I'm going to go look at the fact pattern. So I list my, I write my list A for PR at the bottom there. Clients, left years, counsel, courts feel differently. And then I'm going to go to the call, and I'm going to look for what other subject it is. And here it says Online Inc. was duly incorporated as an internet service provider. Articles of incorporation. So now I know I'm in corporation. So I'm in corporation. So then I just make my list A. So corporations actually, there I'm in BA, but so corporations, I'm thinking of duties. I'm thinking of securities. I'm thinking of formation. Duties, security. I mean, those are really the big piercing the corporate veil. Those are a lot of the big issues, and voting, shareholder rights. So a lot of those kind of issues. So you want to make sure that you have your list A, when you know what all is enveloped within corporations, within agency, what's in partnership. So here, all right, so now I'm going to go through the question, and then we'll go through my list B. So Online Inc. was duly incorporated as an internet service provider. So it's telling us what type of business they're in, which can be important. Its articles of incorporation authorized issuance of 1,000 shares of stock at $1,000 par value. All right, so that means that each stock is worth $1,000. Online initially issued only 550 shares to its shareholders as follows. Dick and Sam each received 200 shares, and Jane received 150 shares. So they have a distribution there. Online's board of directors, composed of Jane, Sam, and Harry, named Jane as the chief executive officer and named Harry as general counsel. All right, so you have Jane as CEO, Harry as general counsel. We don't see a role for Sam in here. So I want to keep that in mind, especially because they asked about his liability at the bottom there. So Online's business grew substantially in the following months. Still, Online was short on cash. So when I see short on cash, I'm thinking of a few different things. I'm thinking, okay, well, what are they going to do as a result of that? But when I see short on cash, I'm also thinking of undercapitalization. So I'm thinking about piercing the corporate veil. Whether or not that comes up, it's just like that's a trigger fact for that. So as a result, instead of paying Jane $10,000 of her salary in cash, it issued her 50 additional shares with the approval of its board of directors. So now Jane has, Jane is on the board. So Jane presumably is voting on the board. It issues her 50 additional shares, though, so that makes her get what Dick and Sam each got, but it's giving her something that's worth a lot more than the $10,000 cash. But there's a cost-benefit analysis there, obviously, that it's risky to take shares, especially when they're short on cash, but she believes in it. She also is a CEO, so that's going to be, she plays up an important role, and they probably want to keep her on. So it's paying her 5 times what she's entitled to in her salary, but she's taking some risk with that, so that's okay. But that is still, that triggers a duty of loyalty issue because she's an interested director and she's benefiting from that transaction. So that's duty of loyalty. So then it goes, looking to expand its operations. So they're trying to expand. Online sought to enter a strategic partnership with LargeCo Inc. Jane had learned about LargeCo through Harry's wife, who she knew was a majority shareholder of LargeCo. So now you have, Harry, who's on the board, there's going to be a duty of loyalty issue there because his wife is benefiting from this, and then also Jane knows about this, but the other board member, Sam, does not know. So we have to make sure that he acquires knowledge for this to be a valid transaction. So Jane directed Harry to negotiate the terms of the transaction with LargeCo. So Jane is directing Harry to negotiate the terms with LargeCo, and essentially to negotiate the terms with his wife. So that's going to be, there's obviously a little bit of a problem there. There could be. In the course of Harry's negotiations with LargeCo offered to acquire the assets of Online in exchange for a cash buyout of $1 million. So that is an asset sale, and an asset sale is considered a fundamental corporate change, and there are some formalities that must be adhered to for a fundamental corporate change. So there's that. So you have that. Harry telephoned Jane and Sam. So now he's telling them about this, and Jane and Sam agreed with Harry that the offer was a good idea, and Harry accepted LargeCo's offer. So Sam is accepting the offer, but he's missing some material information. He's missing information that that Harry's wife is the majority shareholder of LargeCo. So there's a lack of information there. So Sam, at this point, cannot validly determine that. So you would need a majority of disinterested directors to approve it, which can't happen here at this point. All right. So 2 days after completion of the transaction, so it goes through, LargeCo announced a joint venture with TechCo, which is solely owned by Harry. So this is obviously going to be problematic because Harry owns it. That's his business. So they sell online to LargeCo. So they basically sell the assets of online to LargeCo, and then LargeCo enters into this venture with TechCo. So basically, Harry is entering a transaction with his wife 2 days after they complete that the asset sale of online. So this looks really fishy because they're doing this so close in time. The joint venture was valued at $10 million. In its press release, TechCo described the joint venture as a remarkable synergy of LargeCo's new technology with TechCo's large consumer base. So the new technology they're referring to there is online, is what they acquired from online. So it looks as though there was a transaction that was looks like there was a transaction that was entered there by that Harry negotiated with his wife so that he could essentially gain substantially. So that's going to be an issue there. So it's synergy of LargeCo's new technology with TechCo's large consumer base. So TechCo has this consumer base that it looks like it could have, done with online and didn't. Come here. The following week, Dick learned of LargeCo's acquisition of online's asset. An expert in technology matters who was furious about the price in terms of the acquisition, believing that the value of online had been seriously underestimated. So what are Dick's rights and remedies? What are Dick's rights and remedies, if any, against Jane, Sam, and or Harry? Discuss. What ethical violations, if any, has Harry committed? So, all right. So I actually just wanted to go back here to look to see where it first mentions Dick. Is the first mention Dick in the call? Oh no, Dick is one of the Okay, I just wanted to make sure. Okay, so a few things here. So what rights and remedies against Jane, Sam, and or Harry? So there's going to be rights to claim breaches. So the way I set this up, and you could do this a variety of different ways, and I encourage you guys to look at baressays.com too to see how high scoring answers organized it, because I want you guys to kind of get a sense of that too. So the first I go through the breach of fiduciary duties, and I thought it was easier to organize by individual. And then analyze what each individual did and where there was violation, or if they are jointly liable. So I started with Jane. So the duty of loyalty, you have the duty to act in the good faith in the corporation's best interest. So Jane is on the board, and so she owes a duty, which you don't really have to establish, but duty. Okay. So then you have here an interesting transaction. So this for Jane, this is the sales, the 50 stock. So 50 stock, Jay receives them directly. To compensate for or to replace salary. Okay. So it is a self-interested transaction. She's the defendant or a close family member is a party, or a director or a close family member is a party. So here there's a self-interested transaction there. But then you look, okay, well, it has to be disclosed. So first of all, I think that it was disclosed. But even if it wasn't, it would probably be judged fair. It would be judged fair because because Jane is the CEO. Jane is the CEO. There's risk inherent in taking stock instead of taking cash. Well, the fact that Jane is CEO, she's probably important to the company. To online success. There's risk inherent in it. So that's what I would say. So I would think that it would be judged fair. Also, it was approved. It was approved by both. Where is it? Sorry. Approved by the board. And 2/3 are disinterested. Okay, so I think that this is fine. So Jane did not breach her duty of loyalty here. Does that make sense? Did you guys see this as an issue? Because I think a lot of people actually missed this one, the distribution of shares to her. Okay, good. All right, good. So then let's look at Harry. So Harry obviously is in a lot more trouble here. So with the acquisition of online, so engaging in a self-interested transaction, it's not as clear cut here. So you have to look at, are you engaging in a competing venture? So here, actually, let me just pull mine up so I can show you guys too. Okay, do loyal stuff. Okay, so self-interested transaction. So a party where she received additional shares. That's Jane. So here, this is largely with by large co. Competing venture. Okay. Competing venture. All right. So his wife is. Hang on one second. Okay, actually, sorry. This one just goes down. This actually goes down below. So just acquisition of online should be here. And then Techco goes here. So the acquisition of online. So I did it this way. So it's an interested director transaction. Harry's H's wife is majority shareholder. It appears that it was undervalued. Because Dick is a technology expert. And then it also, but here, if you look at the, is a transaction judged fair? Transaction is, transaction not judged fair because it looks as though it was undervalued. Looks as though it was undervalued. And the director's interest or the facts were not disclosed and approved by a majority of the disinterested shareholders because Sam was unaware of H's interest and likely would not approve it, even if and likely would not have approved it. And then there's a counter argument here. So there's a counter argument here. So Jane knew that H's wife was a majority shareholder, but S did not know, which is problematic. So I do think that there's a problem there. I mean, I think you can make an argument either way on the second point here that if the facts were disclosed, that you could get approval by a majority of the disinterested shareholders, because you could get both Jane and Sam to approve it, but I don't think that they would in this instance, just because it does look like, if they went and did it, they might have gotten some additional information, so they could have talked to Jane. Or they might have looked into, why does Harry want to enter into this transaction? But at the same time, S did not know. Online is short on cash, and might have wanted to engage in that asset sale because of that. So may have approved of it. So I think you can go either. I actually do think you could probably go either way there. I still think though that my opinion is that they probably would not approve this because it doesn't look like as though it was fair, and it looks like there was some hiding of information because of the Techco transaction. So now let's look at Techco. So Techco is solely owned by Harry. Owned by Harry, and the venture between Techco and Large Co entered 2 days after completion of acquisition of online. So I think that is a big part of the problem, is that there is this acquisition and obviously the timing of it. So it seems really fishy here. The venture valued at 10 million suggests H could have entered transaction with online. So it suggested he could have entered the transaction with online, which would have made online incredibly valuable. Because it looks like he could have done it either through LargeCo or through online, but Harry's obviously going to get more money if he goes through it with LargeCo, since that's his wife is a majority shareholder. So then we're going to look, okay, well, ways to show whether you are engaging in a self-interested transaction is if you're taking, if it's a competing venture. And it does look like Techco. So Techco, first of all, it's Techco, and then online is an internet service provider. So it looks like they're in the line of business, but then also this looks like a competing venture because I think this looks like a competing venture because it looks like it is in the same line of business. And it looks like Techco could have gone into business with online. So Techco could have gone into business with online. And I actually think you could probably use that for the acquisition of LargeCo too. You could probably do that for either, really. But in corporate, so a line of business. So here it looks as though Techco essentially, it looks like Techco essentially stole the assets of online to an extent. Or maybe you shouldn't say steal, but it looks like he made a really good deal to acquire all of his assets and cut everybody else out. Techco acquired assets of online. Yeah, so it's a consumer base. So Techco has this large consumer base to serve large consumer base that he could have probably served through that he could have served through online. All right, so then remedies of breach. So you can get damages or they can rescind. So collect damages would be whatever the valuation difference. So probably the $9 million between, well, it's not, I think it's $9 million. $9 million. This is the difference between valuation of joint venture and online asset sale. They could also rescind the contract. Rescind the joint venture and the asset sale. Really, they'll probably rescind the asset sale. All right, and then so those are duty of loyalty. That's a duty of loyalty issue with Harry. So those are, first I'm going through duty of loyalty, and I'm going through both Jane and Harry, and then I'm going through Jane, Sam, and Harry for a duty of care. So then I'll look at the stock to Jane. So act as a reasonably prudent person. Here, it's reasonable to give stock, and it's really for all the same reasons as above. So I just copy this. All right, and then also with the asset sale, so duty of care. So the asset sale, was it reasonable to enter it? So here you have Jane knows that H's wife is majority shareholder, which I think is a problem. So probably not acting as a reasonably prudent person, but directs H to negotiate. So that's probably not good. H negotiates despite having conflict or a loyalty issue. So I think both of those are problems. Business judgment rule, they'll presume. So is a business judgment rule going to come in and save it here? Probably not, because, and I'll get this in a second. Yeah, so the other part of it is what I wanted to double check. So there's an issue with committing waste. So there's an issue with committing waste. So when they entered into the transaction with Large Co, that was committing waste because you were essentially selling all the assets for significantly less than what they're actually worth. So also waste committed because sold assets for significantly under value. Okay. Oh, sorry, and then you have BJR. So the court defers to the judgment of the board absent a conflict of interest. So here you have a big conflict of interest. Here you have so you have H's conflicts. So board or court will not. So the business judgment rule presumes that director decisions are informed, serve a rational business purpose, and are disinterested and independent. So a court will not find. So then they're going to evaluate whether it was informed, rational business purpose, disinterested, and independent. So it's not disinterested, not informed, because Sam and Jane did not know about TechCo, it looks like, and S did not know H's wife was majority shareholder. All right, so I think for all those reasons, it's going to fail. Duty of care. There's also a duty of care issue with respect to the fundamental corporate change. So there's the formalities. You have to, there has to be an adoption of a resolution at a special meeting. Written notice has to be given to the shareholders. The shareholders have to approve, and then the articles of incorporation have to be amended. Literally none of this happened here. None of formalities. So then you have, so there's that. So fundamental corporate change. So remedy, so the damages, recover damages. That's why. Okay, so sorry, I mentioned it above, but you can do it below as well. So you have the remedy for the board's violation here. So rescission. So Dick can force a rescission of the asset sale. So if there's grounds for rescission, and then no valid defenses. So the board approved the asset sale despite Harry being an interested director. So court will rescind because of duty of loyalty breach. You can recover damages, and then or restitution. Sorry, yeah, damages for Rob. So then also restitution of any money that Harry. So Harry might have to give online the money that he earned as a result of engaging in the direct interested transaction. So H may be forced to hand over money he earned as a result. Any questions so far? I know there's a lot in this one. That's why I wanted to do this one second. Are you guys following along okay? wait, hang on 1 second. Direct actions, restitution, rescission, is it? Yeah. So the restitution, you could also just say monetary damages. Yeah. Sorry, that actually should be here too. Yeah. So you could do the monetary damages for whatever, for the loyalty, which is going to be the same as the restitution. So money obtained as a result of the breach. So, and it's actually a good idea, Myra, bringing up direct action, so direct versus derivative, that's a good idea here too. I actually didn't get into this because it's not, I didn't get into that because it's not totally necessary here, but I do think it's a good idea, like, can he bring this up? He's a shareholder or he's a board member, what can he do? And yeah, so he's a shareholder, not a board member, he's a shareholder, and as such, he can claim breach. So he can definitely bring that. All right, so, but yeah, direct, or he would have a claim as direct or derivative. You thought it was just about direct and derivative? All about that? I mean, no, yeah, I mean, it's definitely not all about that. There's all these other facts about, like, there's all these interested director facts. There's transactions and, like, people making money and all of that. But no, I mean, like, a direct action, I mean, it's okay if you, like, when I do talk about direct action, I do it at the very top, direct versus derivative. So that's what I do when I talk about it. And I was going to mention that at the end. But I just wanted to check in right there. But that's it's just a small part of it, because you're just saying, can you bring an action, and on what basis? And if you can get to these issues on what basis, if by talking about the violation, so you could do it that way, but it's not just a conversation about direct versus derivative. Yeah. Breaches. Okay. I don't know, I might have just not, yeah, the director's breaches. Yeah. Well, Jane, Sam, and Harry are the board. So is that why you're like, when I mentioned the board? I'm just trying to get where the confusion is. You guys have mics, you can talk so I can hear you if it's easier. You don't have to type it. Or not. Okay. Oh. All right, Myra. And oh, okay. So if it's just a different, I mean, but as long as you hit the issue, like, that's what I said, you could organize this a lot of different ways. So, like, if it's an organizational thing, but you still hit all of these issues, then that's fine. So, like, there are definitely different ways. That's why I was saying you should look this up at rsa's.com to see if there was a different way to organize it. Just for me, for me, it was a little bit easier to look at it this way. That's all. I often tend to break it down quite a bit, just because I think it's easier to follow that way, versus not breaking it down as much. All right, let's talk about the yeah, Myra, I mean, I think that's okay. I think that's okay. Yeah, that's totally fine. That's completely fine. I just don't, direct versus derivative isn't a big deal. But yeah, you do want to establish that you can bring the suit. So yeah. All right, so let's talk about the ethical violations really quickly here. So I generally establish that there's an attorney-client relationship. There is one here because he's general counsel, because Harry is general counsel. So I would talk about that. And then I have duty of loyalty. So that is a duty to avoid conflicts of interest. So is there an actual conflict of interest? So he's a sole owner of TechCo. So he is, oops, let me do this. So H is the sole owner of TechCo, but GC for online. So so he's basically working, representing himself, or he's working for a business that has a direct conflict because it looks like they're competing. And it looks like TechCo is competing with online. or not competing with, but competing is not the right word. TETCO could, it looks like TETCO could have entered the transaction with online rather than allowing large code to do it. So that's a problem there. So there's an actual conflict there. And we've established it above that there are duty of loyalty violations with respect to the breach of the fiduciary duties, because it's an interested transaction. So it looks like he's doing something that's adverse to the business. So there's an issue there. So he's the sole owner of TETCO, and also his wife is the majority shareholder between LargeCo, and then wife is majority shareholder between, or not between, of LargeCo. So I think that there are, so there's definitely some conflicts of interest there. So with a conflict, you can represent despite the conflict if you obtain consent. So there's obviously a few different ABA. You have to reasonably believe can provide competent rep, not prohibited. Does not involve an assertion of one claim against another, not client versus client, and informed written consent. And then California eliminates the reasonably believes requirement. Okay. So here, there was no written consent. No written consent. So, I mean, just that alone, it's not prohibited. It's not a client versus client, but there was no consent, so there's a violation. In California, there's you do have to get consent as well. No written consent. So there is an issue there. So duty of loyalty, there's a violation. And then duty of competence, and this is with respect to the fundamental corporate change. He failed to, so H is the general counsel of online, and he failed to follow corporate formality. He failed to follow the formalities for a fundamental corporate change. And you know that because Dick didn't learn about this until the following week. About the acquisition until the week after the asset sale occurred. And that's it. So that's it. So for the PR, so the reason I like these two essays is because they're kind of flip-flopped. They deal with different issues with respect to BA, and they deal with different issues with respect to the PR issues. The second one is obviously heavier on the BA part, lighter on the PR, and the opposite for the first one that we did. Do you guys have any questions about this one? I'll assume it's a no. Okay. Yeah, I know this, Myra, just to address that, this essay does tend to freak people out a little bit. But you should look at, like, it's like after I would see an essay like this and I would kind of, panic a little bit. Then I would go on bar essays. I would look at it. I would see what was going on. I would see, I'd be like, oh my God, like I did so terribly. How did I do that? And then I would look at bar essays and I would feel better about myself. Like, okay, like I actually, look at 65s and compare to how you did it with theirs. And like, also just know that, that there are different ways to organize it. So it's good to look at the different ways that people did it on bar essays compared to the selected answer, etc. Yeah, Adam, the ethical violations is just PR. Yeah, just ethical violations, yeah. All right, so tomorrow night is the last workshop, so it's wills and trusts and community property. So I have a couple of crossovers of those, or I might just do one of each. So that is what I meant to say. So because I want to kind of get deep into each of them. So we'll do those. And yeah, I'll see you guys tomorrow night. Have a good night. Thank you. Good night, Lorena.